The British government wants to outsource the asylum process. Migrants should in future wait in Rwanda for their procedure, supposedly to spare them the potentially deadly voyage across the English Channel. However, refugees who are already in Great Britain should also be flown to East Africa. So in the future, anyone who wants to apply for asylum in Great Britain should wait in Rwanda for approval. British Home Secretary Priti Patel wants to sign a corresponding agreement in the East African country today when I'm filming this. That's what the government in London announced. According to Prime Minister Boris Johnson, this is intended to prevent people from making the dangerous journey across the English Channel and stop illegal migration. Migrants who enter the UK without permission should first be flown to Rwanda. Refugee organizations reacted with outrage. Johnson defended his plan, of course, and too often the hopes and dreams of migrants are exploited by criminals. These vile people smugglers abuse those in need of protection, turning the English Channel into a watery graveyard where men, women, and children are drowning in unseaworthy boats and freezing to death in freezer trucks, the Prime Minister was quoted as saying in the statement. In November 2021, 27 refugees died when their boat capsized. Johnson, and above all Home Secretary Patel, are under considerable pressure in the Conservative Party because of the so-called small boat crisis, as illegal migration is known in Great Britain. Thousands of people are still reaching the country from France in small boats, despite promising to significantly limit immigration with Brexit. Patel keeps trying to appease the hardliners with radical proposals. So she brought up the idea that the Coast Guard could push back the refugees' inflatable boats on the open sea. There was also repeated discussion about reception camps for asylum seekers that were far away. However, several countries rejected this. The Geneva Refugee Convention is regularly mentioned because of Patel. But what is it about? The convention relating to the legal status of refugees, better known as the Geneva Refugee Convention, was adopted at a special UN conference in Geneva in 1951 to establish a legal basis for dealing with the mass displacement and refugee of World War II. It builds on the 1948 Declaration of Universal Human Rights, which enshrined the right to seek asylum from persecution in other countries. At the same time, the convention defined the scope of activities and the legal basis of the UN Refugee Agency UNHCR. Initially limited to Europe and the causes of flight before January 1st, 1951, this geographical and temporal limitation quickly became obsolete with the anti-colonial wars of independence and the wars in Southeast Asia, and was abolished with the Additional Protocol of 1967. The adoption of the protocol was crucial as phenomena of flight and expulsion have increasingly been concentrated in the global south, and this has been the case up to the present day. The central aim of the convention is to create a uniform definition of the rights and obligations of refugees. That means people who leave their country of origin out of a well-founded fear of persecution because of their race, religion, nationality, membership of a particular social group, or because of their political convictions. Refugee rights include protection against discrimination, the issue of a travel document, impunity for illegal entry, you hear, and protection against expulsion, the so-called principle of non-refoulement, as long as the refugee status of a person has not been clarified. Flight is rarely a linear phenomenon that can be traced back to one cause. A multitude of political and financial borders and hurdles restrict freedom of movement, and often different motives for leaving the country of origin overlap. The narrow understanding of the political reason for fleeing, which according to the convention is a prerequisite for refugee status and limits access to international protection, has always been heavily disputed. Contrary to popular belief, flight from war or civil war does not result in recognition as a refugee under this convention, although in these cases states often grant temporary subsidiary, that means temporary protection. It has also long been disputed whether the convention covers gender-based persecution, but a 2002 UN directive provides for the interpretation of the convention in this sense. The 48 million internally displaced people worldwide are also not protected by the Convention because they have not left their country of origin, even if the reasons for their displacement are political as defined by the Convention. Further structural problems of the Geneva Convention become apparent with a view to two of the most pressing challenges of our time: the climate crisis and the massive global unequal distribution of income and prospects. The climate and environmental crisis is reflected in a global spread of ecologically unstable regions that are affected, for example, by desertification, drought, or pollution. In addition, there are increasingly violent weather events and natural disasters. However, anyone who decides to flee to another country as a result of these developments cannot hope for international protection within the meaning of the Geneva Convention. The same applies to people who do not want to stay in their country of origin because of their socio-economic situation. The reason for this is the central concept of persecution in the Refugee Convention. Even if intolerable ecological and socio-economic conditions prevail, caused by state inaction or failure, asylum seekers can hardly prove an individual persecutor from whom protection is granted under the Geneva Convention, and it should be granted. If one realizes that climate change is mainly caused by the global north, but the consequences are most severe in the global south, controversial questions about global protection responsibilities arise there. The same applies to the global economic order and the extremely unequal distribution of wealth, which are political in nature and have an enormous, albeit indirect, impact on refugee and migration movements. More and more voices are calling for migration and displacement due to environmental changes to be included in the Geneva Convention as a legitimate reason for international protection. But I disagree with those people, by the way. At the same time, words like climate refugee can simplify complex contexts in a problematic way and distract from deeper reasons. Environmental changes usually happen gradually, and their socio-economic consequences unfold just as gradually. There is no clear connection between flight and climate change. Rather, it depends on the political and economic circumstances whether people can adapt to changing environmental conditions or not. A reform of refugee protection would have to include the political structural responsibilities for climate change and adaptability and expand the narrow concept of political persecution in the calls for the reforms there. But as I said, I disagree there. An international convention is only as effective as the states that are supposed to implement it. In times of a rapid decline in the willingness to accept refugees, particularly in countries of the global north, various strategies can be observed to limit or even prevent the right to asylum. The current and harshest example from Great Britain by Priti Patel is one of the most glaring, but not the only one. The so-called externalization of the EU's external borders offers many examples of this, the most well-known being the European cooperation with the Libyan Coast Guard. They are recruited from militias and prevent boats sailing from Libya from entering European sovereign waters. This leads to accusations that the EU indirectly disregards the principle of non-refoulement. In addition, there are thousands of illegal returns across the border, so-called pushbacks, which have been carried out for years by European member states with the support of the European Border Agency Frontex. That's at least what is reported. Furthermore, the third country regulation is used to make it more difficult for asylum seekers to obtain asylum in Europe. It was only on July 7th in 2021 that the Greek government declared Turkey a safe third country for Afghan asylum seekers. Turkey is not ready to take back rejected ones, and this means that people from Afghanistan can neither advance nor retreat if they are being held on the Greek islands and cannot individually prove that they are in danger in Turkey. In addition to the important discussion about possible extensions of the Geneva Refugee Conventions, it remains to be said that the protection enshrined in it can only be effective if states guarantee practical access to this protection. At the same time, the adoption of the Convention was a historic milestone and still offers a central point of reference for ensuring that human rights are enforced worldwide. And I'll see you in my next video. Bis gleich.